Greetings everyone, I am Ngabuto Nicholas Mabena. When we're discussing the migration passport, we spoke about the Asylum. We did give advice on how one applies for an Asylum document in South Africa if they want to relocate to South Africa for the purposes of asking the South African state to protect them from persecution. But there are those that are already in South Africa that are applying Asylum for Asylum documents, or others who are already holders of the Section 22 document, which they renew from time to time. Some have been rejected, but some are finding difficult to access the refugee offices to renew their Asylum documents or even to apply. As a result, some of them then get arrested by the authorities. The human rights organizations now want the Refugee Act amendments declared unconstitutional. There's an article that appears on internet written on the 28th of February 2025. You can check out that article. The headline says, or is titled, "People trying to seek Asylum should not be deported, court hears." The article says Asylum seekers without valid visas face arrest and deportation even if they have tried to apply for Asylum. We know that during COVID, people were asked to renew online. Some did manage to renew, some failed to renew. The minister has been talking about clearing the backlog. Other people are still struggling to get their Asylum documents renewed. Here it says, Scala-Brin argues this is unconstitutional and violates the principle of non-refoulement. Home Affairs acknowledged that mistakes have been made but argues the law is sound. So it says amendments made to the Refugees Act in 2023 are unconstitutional because they allow Asylum seekers to be deported before they are able to access the Asylum system. This puts them in danger and at risk of persecution. This was the main argument made by the Scala-Brin Center of Cape Town, an immigration rights organization in the Western Cape High Court before a full bench on Tuesday. The amendments, which Scala-Brin wants the court to declare unconstitutional, allow for Asylum seekers who have entered the country unlawfully and do not have a valid visa to be denied full access to the Asylum system after an initial filtering interview with an immigration officer. During this interview, meant to filter out non-credible Asylum applications, the immigration officer must consider whether the Asylum seeker is able to explain why they are in the country unlawfully. The applicant must show good cause for breaking the country's immigration law. Scala-Brin, represented by lawyers for human rights, cited international and local case law to argue that no matter how late the person is in applying or whether or not they have entered the country lawfully, they should be allowed to apply for Asylum and they should not be deported until their Asylum applications are rejected on their full merits. This is what we always call for, because a person, as we said in the last video, in most of the cases, they do not plan to come. If a person is a victim, they simply leave their country of origin, running away from persecution. They get in South Africa, they need to be protected, and these people in the main, they will not have used official entry points because they will not have acquired passports in their country of origin. Because if the authorities in your country of origin are looking for you, you can't then go to a government office, apply for a passport. So it means that a person would come to South Africa illegally or not through the official channel. Here it says, amendments gain access to the system upon the sole discretion of an immigration officer who is not trained or experienced in assessing the merits of an asylum application, and as a consequence, South Africa risks sending people back to danger in their countries of origin, Salab Green argued. This violates international law, including the principle of non-refoulement. Amnesty International, the Global Strategic Litigation Council for Refugee Rights, the International Detention Coalition, and the Helen Suzman Foundation joined the applications as amicus curiae, that is, friends of the court. The organizations highlighted the multiple international treaties and the instruments South Africa needs to honor. The Helen Suzman Foundation pointed out that the amended act puts children at risk in that their status is tied to that of their parents. So we are following closely this case, which is before the High Court in the Western Cape. Let's conclude by reading this. The matter heard on Thursday was Part B of Scalabrini's application. Part A was heard in August 2024. That application sought an urgent interdict against the arrest and deportation of asylum seekers, including people who indicate they want to apply even if they have not yet done so. In September, the court granted an interdict against deportation but not against the arrests. Because of the interdict, the Department of Home Affairs effectively shut off all access to asylum system for new applicants. But the arrest of people who want to seek asylum but who do not have valid visas have continued. Because the government is interdicted from deporting asylum seekers, thousands of people are in prison. Judge Judith Cloete said she was concerned that making an order setting aside the amendments would have unintended consequences for the government. Cloete asked Arendse and his team to advise what relief would be appropriate and feasible should the court rule in Scalabrini's favor. So we are following closely this case. If you are an asylum seeker in South Africa, please write in the comment section. We know you have a lot to tell us. Please do indicate in the comment section. Please like this video, subscribe to this YouTube channel. If you are on TikTok, please do follow us. Otherwise, goodbye.